Don't you ever. Bondi threatens Congressman live after he reads FBI documents she cited didn't exist. A witness called the FBI, filed a statement, named names, then waited. For months, that statement sat in a federal record system untouched while the Department of Justice told Congress there was no evidence. Then Joe Neguse walked into a hearing room with a printed copy of that statement in his hands and read it out loud directly to the Attorney General's face. What happened in the next 60 seconds will be in the congressional record forever. That is the detail that matters, not the words themselves, though the words are the kind that don't leave a room once they've been spoken into a microphone. Not the warning embedded in them, or the silence that followed, or the way the hearing seemed to hold its breath for exactly 3 seconds before anyone moved. The detail that matters is that the document was already there. Physical, real, time-stamped, filed in the federal government's own record system, sitting on the surface of a congressional hearing table in front of Pam Bondi while she told the room it didn't exist. She said there was no evidence. He read from the document. She said, "Don't you ever accuse me of a crime." And the room understood, in the particular way that rooms understand things that are happening in real time and cannot be unhappened, that something had just shifted, not in the political sense, not in the partisan sense, in the simpler and more permanent sense of a fact entering the record and staying there regardless of what anyone said afterward to try to change what the record showed. The fact was this: Pam Bondi had made a sworn statement about the non-existence of a piece of evidence while that piece of evidence sat on the table in front of her. And when the discrepancy was named out loud, her response was not to address it. Her response was a warning. That is what happened. Everything else is the story of how it got there. The hearing had been running for hours before the document appeared, long enough that the rhythm of it had established itself in the room. The call and response of congressional oversight, the question and the deflection and the follow-up and the longer deflection and the procedural interruption and the return to the question and the deflection again. Bondi had arrived with a strategy that was visible from the opening exchange. Staff had prepared her not with answers, but with attacks. Every question about the Epstein files was met with a pivot to something else. Every request for documentation produced a personal jab at the member asking. Every attempt to hold the proceeding to its stated purpose. A reckoning with why the legally mandated release of the complete Epstein file archive had been mishandled. Produced a line from a binder that someone at the Department of Justice had spent time writing when they should have been preparing legal justifications. The binder was the tell. You bring a binder full of attack lines to a hearing when you have nothing else to bring. When the legal position is indefensible and the documentary record is damning, and the only remaining tool is the hope that if you make the hearing uncomfortable enough for the people asking the questions, they will stop asking them. The mechanics of that strategy deserve examination because they reveal something about the calculation being made in the Department of Justice before that hearing ever began. Someone made a decision, not a passive decision, not an accidental omission, but an active, deliberate choice about how the Attorney General of the United States would spend her preparation time ahead of a congressional oversight hearing into her department's handling of the most politically sensitive investigative files in modern American history. That someone, or those someones, looked at the situation and concluded that the most effective approach was not to prepare legal defenses for the document handling decisions that Congress was going to ask about, not to assemble the documentary record that would explain the redaction choices and the timeline and the compliance status, not to walk through the specific provisions of the statute that mandated the release and construct a coherent legal argument for why the department's actions fell within the law. They prepared attack lines instead. That choice is a confession, not a legal one, not one that could be introduced in a courtroom or cited in a charging document, but a confession in the plain sense of the word, an admission through conduct that the thing being concealed exists and that concealment is the strategy because defense is not available. You do not spend your preparation time writing insults if you have answers. You write insults when the answers are the one thing you cannot say out loud. And then the document appeared, and the binder stopped working. The questions did not stop. They had been building toward the document for some time before it appeared. Joe Neguse had not rushed. He had laid the foundation methodically, the way someone does when they know that what they are about to present is going to require context to land with the weight it deserves. He had established the timeline of the investigation, the years of federal work, the millions of pages of documentation, the network of individuals whose connections to Epstein's operation had been mapped and recorded and preserved in files that the law had finally explicitly required to be made public. He had established what the Department of Justice was supposed to have done with that record and what it had chosen to do instead. Then he asked the question, He asked whether there was evidence connecting the President of the United States to the operation run by Jeffrey Epstein. Bondi's answer came without hesitation. There is no evidence that Donald Trump has committed a crime. Everyone knows that. This has been the most transparent presidency. 3 sentences. Confident. Practiced. The kind of answer that sounds like a closing argument when it is delivered that way, with that tone, in that setting. The kind of answer designed to end a line of inquiry by making the inquiry itself seem unreasonable. Then he picked up the document. It was a witness statement, filed with the FBI's National Threat Operations Center. The mechanism the federal government maintains specifically so that ordinary citizens can report information, threats, observations, evidence to federal law enforcement. This was not a rumor, not a secondhand account passed through 3 intermediaries until it no longer resembled whatever it had started as. This was a formal filing, time-stamped, preserved, part of the official federal record. The individual who had filed it had been in a position to observe directly. They had driven a limousine. They had been present when a phone call was made. They had overheard a conversation between 2 men whose names appeared throughout the federal investigation into Epstein's network. They had subsequently encountered a young woman who described in specific terms what had been done to her and by whom. They had been disturbed enough by everything they had witnessed to contact the FBI and place it all on record. The Department of Justice had never interviewed this witness, not a phone call, not a formal request, not a letter acknowledging receipt of the statement and indicating that investigators would be in touch. Nothing. The statement had entered the federal record system and stayed there untouched, while the department that was supposed to be pursuing accountability for over 1,000 survivors of Epstein's trafficking network spent its preparation time writing attack lines for a congressional hearing. Joe Neguse read from the document, not all of it, the key passages, the specific details that placed the witness in proximity to the president and to Epstein and to a young woman who described being assaulted. He read them slowly, the way you read something when you want the room to understand that every word is already on the record, and the question is not whether the record exists, but whether the person across the table is going to acknowledge what the record shows. When he finished, he looked up, and he asked, "Why has no one from the Department of Justice spoken to this witness?" Bondi said there was no evidence. The room registered this in layers. First the words themselves, then the document still in his hands, then the gap between the two. The distance between the sworn statement that no evidence existed and the physical object containing evidence that was at that moment sitting on a congressional hearing table, time-stamped and filed and real. The congressman named the gap. "I believe you just lied under oath." He did not shout it. He did not perform it. He said it the way you say something when you have looked at a document and looked at a statement and concluded that the 2 things cannot both be true and that you are required in that room, under those circumstances, to say so out loud. 7 words, flat, direct. Delivered into a live microphone in a federal hearing room, on the record, to the Attorney General of the United States. The room stopped. The stenographer's fingers paused above the keys for exactly 1 beat before continuing. The aides along the walls stopped their side conversations. The reporters in the gallery who had covered hundreds of these proceedings and thought they had cataloged every possible thing a congressional witness table could produce looked up from their notebooks. The members of the committee who had been reviewing other documents put them down, because that sentence, that specific combination of words in that specific setting, was not the kind of thing that gets said in congressional hearing rooms. It is the kind of thing people think. It is the kind of conclusion that gets written in legal memos and whispered in hallways, never said out loud to the face of the person it concerns. What makes hearing rooms function, even when the answers are evasions and the testimony contradicts the record, is the unspoken agreement to frame everything as interpretation, not accusation, to keep the surface of the proceeding intact. He broke that agreement. He said the thing directly. And the room stopped because rooms stop when someone decides the pretenses cost more than the confrontation. The stopping is recognition. It is the sound of everyone understanding that the rules just changed. He said it anyway. And Bondi's response, the response of the nation's chief law enforcement officer, the head of the department responsible for prosecuting perjury, the person whose entire professional identity rested on the premise that she was committed to the rule of law and the pursuit of truth, was not to address the document, was not to explain the discrepancy, was not to say, "You are wrong, and here is the evidence that proves it," was not to say, "I was not aware of that specific filing, and I will direct my department to review it immediately," was not to offer any of the dozen available responses that a person who had been falsely accused of a crime could offer to demonstrate that the accusation was false. She said, "Don't you ever accuse me of a crime." 7 words, answered by 7 words. His were a legal observation grounded in a physical object. Hers were a warning, not a refutation, not a correction, not an explanation, a warning, a declaration that the act of making the accusation, not its accuracy, not its evidentiary foundation, not its legal basis, was the thing that required a response, a signal that the space between the document and the sworn statement was not a space she was prepared to enter, and that the appropriate response to anyone who tried to pull her into it was to warn them against trying. Don't you ever? In a courtroom, a judge would mark that answer non-responsive and direct the witness to address the question. In a hearing room with no judge and no procedural mechanism to compel a direct response, it landed differently. It landed as what it was, a threat issued by a powerful person to a less powerful person who had just said something the powerful person could not afford to have said. The grammar of it was unmistakable. Don't you ever? Not that is incorrect. Not I dispute that characterization. Don't. You. Ever. The word ever is doing significant work in that sentence. Ever is not a legal term. It is not a procedural instruction. It is a temporal boundary, a declaration that the prohibition being issued extends forward into all future moments, covering not just this instance of the accusation, but every possible future instance of it. Don't you ever means not here, and not again, and not anywhere, and not in any context. It means the accusation itself, regardless of evidence, regardless of record, regardless of what any document on any table in any hearing room might show, is permanently off limits. That is not how law works. That is not how congressional oversight works. That is not how sworn testimony works, or how the institutional relationship between the executive branch and the legislative branch is supposed to function. Accusations made in congressional hearings on the basis of documentary evidence are not subject to prohibition by the person the accusation concerns. The word ever has no legal force in that setting. It cannot be enforced. It cannot be cited in a ruling or used as grounds for a procedural objection or entered into the record as a binding constraint on the conduct of the proceeding. What it can do is tell the room something about the person who said it, about the calculation being made behind it, about what the warning was designed to accomplish and what its issuance revealed about the resources available to accomplish it. The silence that followed lasted longer than silences in congressional hearing rooms usually last. And in that silence, the room did the arithmetic. Document plus sworn denial plus warning equals something that the permanent record will now carry forward, available to anyone who wants to understand what happened when the Attorney General of the United States was asked to account for the distance between what she said under oath and what a federal document showed. There is a specific quality to the silence that falls after warning lands in a room that expected an answer. It is not the silence of shock or confusion. It is the silence of recognition, of people understanding simultaneously that what they have just witnessed is not a procedural dispute or a legal argument or a difference of interpretation. It is the sound of an institution protecting itself from a question it cannot answer by threatening the person who asked it. The hearing continued after that. Questions were asked. The binder was consulted. Deflections were produced. The procedural machinery of congressional oversight ground forward. But the 7 words were already in the record, both sets of them, sitting next to each other in the permanent transcript, available to anyone who wanted to understand what had happened in that room and what it meant. What it meant was not complicated. The warning was loud. The statement it was trying to silence is louder. The FBI's National Threat Operations Center exists for one purpose. It is the channel through which citizens report information to the federal government. When a statement enters that system, it does not disappear. It becomes a federal document. It gets filed. It gets preserved. It creates an obligation, not necessarily to prosecute, not necessarily to open a formal investigation, but to evaluate, to review, to make a documented decision about whether what has been reported warrants follow-up and why. That obligation is not discretionary. It is not subject to the political preferences of whoever happens to be leading the department at the moment the statement arrives. It is a procedural requirement built into the record system for a reason. The reason is accountability. The reason is that the federal government cannot credibly claim to be pursuing the full scope of an investigation while simultaneously ignoring witness statements that arrive through its own official reporting channels. The reason is that when someone takes the risk of calling the FBI and putting their account on record, the minimum the institution owes them is documentation of what happened to that account afterward. That documentation should exist. The congressman asked for it by implication when he asked why the witness had never been interviewed. He was asking not just about the interview itself, but about everything that should have surrounded the decision not to conduct it. The review, the evaluation, the recorded conclusion, The chain of decisions that led from a time-stamped witness statement in federal files to a complete absence of any follow-up contact. The answer to that implied question was a warning, which means one of two things is true. Either the documentation exists and Bondi knew it existed and chose to issue a warning rather than produce it, in which case the refusal to produce it is its own kind of answer. Or the documentation does not exist, in which case the absence of it is an answer of a different kind. The answer that says no one in the Department of Justice ever formally reviewed the witness statement at all, that it entered the system and stayed there unexamined, that the decision not to follow up was not a decision in any formal sense, but simply the absence of action, which is a different and in some ways more damning thing than a documented decision made for articulable reasons. Either way, the warning was the wrong response. There is no version of events in which the correct response to a congressman holding a federal document and asking why no one followed up on it is to warn him not to accuse you of crimes. There is no legal framework, no prosecutorial standard, no institutional protocol that produces a warning as the appropriate answer to that question. Warnings come when people are out of other options. And the Attorney General of the United States in that hearing room on that day had run out of other options in 60 seconds flat. He asked for it. She warned him not to accuse her of crimes. The gap between those two responses, between producing documentation and issuing a threat, is not a legal or procedural subtlety. It is the distance between an institution that has nothing to hide and one that does. And that distance is now part of the permanent congressional record, documented on camera, preserved in the transcript, available alongside the witness statement that created it and the sworn statement that denied it. Three things in the record now: the witness statement, the sworn denial, the warning issued when the contradiction between them was named. None of them have been resolved. The witness is still willing to speak. The interview still has not happened. The documentation of why no follow-up was conducted has not been produced. The gap between no evidence and here is evidence remains open, sitting in the federal record exactly where the congressman left it when the hearing ended and the room emptied and the cameras stopped running. Think about what the resolution of that gap would require. It would require the Department of Justice to produce one of two things. Either the record of a documented decision, a formal, articulable, legally grounded conclusion that the witness statement did not meet the threshold for follow-up signed by the appropriate official and preserved in the case file, or an explanation for why that record does not exist. Both of those things are producible. Both of them can be requested by Congress. Both of them are subject to subpoena. And the absence of either of them from the hearing room on the day the Attorney General sat under oath and said there was no evidence is itself a document in the case. The absence of documentation is documentation. It is the shape of something that was removed or never created, and that shape is visible to anyone who knows what to look for and has the authority to demand it be explained. Congress has that authority. It exercised it that day, and the result was not an explanation. The result was a warning. Don't you ever accuse me of a crime. Consider what that warning cost, not politically. The political costs are obvious and ongoing and will be calculated by people whose job it is to calculate them. What it cost in the simpler and more permanent sense of what it added to the record. Before the warning, the gap between the document and the sworn statement was a gap that required explanation. After the warning, the gap was still there, and now the warning was there too, sitting next to it, confirming through the grammar of threat rather than the grammar of refutation that the gap was real and that addressing it was not something the Attorney General was prepared to do. Warnings replace answers only when answers are unavailable. That is their function in rooms like this one. They are the last tool available when the documentary record has been exhausted and the legal arguments have collapsed, and the only remaining resource is the implicit power differential between the person behind the witness table and the person in front of it. Don't you ever is not a legal defense. It is not an evidentiary response. It is the sound of power asserting itself in the absence of truth. It did not work. The document was still on the table. The record was still in the federal files. The witness was still willing to speak. The gap was still open. And the warning was now in the record alongside everything it had failed to close. The document went wherever documents go after hearings. Into files, into records, into the permanent archive of a proceeding that will be referenced in future discussions of this period of American governance for as long as those discussions happen. But the warning is in the archive too. sitting next to the document that prompted it, sitting next to the sworn statement that the document contradicted. All three of them together in the same record, telling the same story about what happened in that room when the Attorney General of the United States was handed a piece of paper she had just sworn did not exist and was asked to explain the distance between the paper and the oath. She didn't explain it. She warned the room not to ask. Don't you ever. 3 words that will outlast the hearing, that will outlast the binder and the attack lines and the deflections and the pivots and every other tool deployed in that room to prevent the questions from getting answers. 3 words that are themselves an answer. Not to the question that was asked, but to the question underneath it. The question of what the Department of Justice is protecting and why and for whom. The document is still there. The witness is still waiting. The gap between the oath and the document has not closed. It has widened because now it contains the warning too. 3 things where there should have been 1. A statement, a denial, and the sound of power reaching for the only tool it had left when the truth was the one thing it could not produce. And somewhere in the federal records of the most powerful law enforcement agency in the world, untouched, unreviewed, sitting in exactly the place it was when a congressman picked it up and read from it in a federal hearing room and said 7 words that stopped the room. The statement remains, filed, preserved, real, unanswered. Everything she said it wasn't. Everything the warning could not make it stop being. Everything the permanent record will carry forward into whatever comes next. The next hearing, the next subpoena, the next moment when someone picks up a document and reads from it and asks a question that keeps not getting answered. It is still there, waiting.